Good evening, everybody, and welcome to another edition of the South Florida Tribune podcast. My name is Scott Morgan Rothwith, along with my co-host Ron Renzy, and Ron happens to be our legal analyst. And Ron, glad to have you back on the broadcast.
Thanks, Scott. It's a pleasure to be back.
Well, Ron, you're definitely a big permanent part of what we do here at the South Florida Tribune, and it's always great to be working with you through the Coral Springs Regional Chamber of Commerce. And, you know, I know you're involved with a lot of facets of the operation, besides helping us, as well as now emerging as a fledgling broadcaster, for sure. So, with that said, Ron, let's talk about our focus for the night, and that's small claims court in Florida. So what I'd like you to do, Ron, is why don't you go ahead and inform our listeners what small claims court in Florida is, or let alone small claims court, period.
Sure. Well, small claims court, every state has them. I'm going to focus on Florida, but there's generally every state has them, and they're dealing with smaller cases. For instance, in Florida, small claims court is part of the county court. Each county has a county court, and they have a small claims division of the court. A small claims case is basically any legal action filed in a local county court to settle minor disputes among the party. Even though it says minor, it's not all that minor. For instance, as of the beginning of this year, on the 1st of January, the dollar amount for small claims case was increased to $8,000. It used to be $5,000. And that's excluding costs, interest, and any attorney's fees. So that's basically any claim of $8,000 or less. So it's really not as small as one would think, but it's considered small claims court. The idea of small claims court is a person could represent herself and go to court and not to have an attorney. Now, there are forms that have been approved for statewide use within the Florida Small Claims Court rules, which anybody can get online. And whatever county you're in, for instance, we're in Broward, but in any county, you can go to the local clerk's office and provide copies of the forms. Now, how do you file a small claims action? You just don't go to the court and say, I'm filing suit. You have to file paperwork. You file something called a statement of claim. This is a complaint to initiate the lawsuit. This is where you have to do it. It has to be in writing, and it has to allege your facts that you say are the basis of your lawsuit, and a cause of action. A cause of action is basically your claim, whether it's a breach of contract claim, whether it's a injury claim. That's your cause of action. Now, when you file suit, if you're the person suing, you're either the plaintiff or the petitioner, and the person or entity that you're suing, whether it's a company or person, is the defendant or the respondent. Now, you have to file your small claims case with the clerk in the appropriate county. Florida now has an online filing system. Now, if you're acting pro se, and all pro se means is you represent yourself. It's just a fancy Latin term. As you know, law is full of fancy Latin terms. So you're pro se, you file your case. Now, you can do it in the clerk's office, or you can do it online. All Florida lawyers have to file everything online now, so it makes it a lot easier. You can log on to what's called the eFlorida portal, and you can get your case filed. The fees, everyone asks, what are the fees for small claims? And it varies by county, because each county can set it up, and also varies by the amount in controversy. The amount of controversy is just another fancy way of saying how much is somebody suing for. Your fees can be anywhere from $50 to $300. So say you're suing for $200, your fees can be less than if you're suing for the whole $8,000. Pretty simple, and that's the way for the counties to make money, depending on the amount of the case. I can't even tell you all 67 Florida counties what the fees are, because it varies in each county, but that's kind of a rough range we can go through there. So, let's say you get your case filed. It's filed in the court system. Are you done? Well, no, you're not, unfortunately. The next thing you do is you have to serve the entity or person that you're suing. Now, when you file a small claims court, which is different than other courts, let's say, which would be for larger amounts, you get the clerk's office produces a paper called summons/notice to appear, which you get from the clerk's office when you file, and it says the date and the time that you have to go to court. So, how does the person you're suing know about it? They have to be served. Now, served is really an old-fashioned way of getting things to people. Service means actual handing it to them. It has to be in-hand personal service generally. but anybody can't serve. I can't serve. You can't serve unless you're a licensed process server. So there's two ways in Florida to get your case served, either by the local sheriff in the county and where the person resides that is being served, or by a private process server. The sheriffs are backed up, so sometimes it's more economical to go to a private process server, which is a little more expensive. The fees range anywhere from $40 to $50. So when you serve somebody, you have a copy of the statement of the statement of claim, which is the complaint, as well as the summons and notice to appear. That's pretty much getting the case filed. Okay. So when you get the case filed, you have a pretrial. The court sets the date, and you have to go appear in person, either yourself or through your attorney. But if most of the time if you're handling it yourself, you're going to go and appear. That is called the initial pretrial conference. Now, generally at the pretrial conference, the judge will the clerk will call everybody that's in the courtroom, make sure you're there, and if all the parties are there, the judge will call you up in order and say, tell me what your case is about. You tell the judge a little bit what your case is about very briefly. The other side says, yes, I agree, I owe the money, or I don't agree, I owe the money. Most of the time they're not going to agree. If they agree, great, then you're done and you get your money. But things in the world of the law is usually not quite that simple. So the judge will send you to what's called to mediation. Now what mediation is you go to a neutral third party. It's not the judge. In small claims court, the beautiful thing is they have mediators there that are paid by the court. So you don't have to pay for mediation. So you go to mediation with your neutral mediator, and the mediator's goal is to facilitate the resolution of the dispute, basically by supervising the exchange of information, ideas between the parties in a bargaining process. Usually, the three, let's say it's a plaintiff, a defendant, and a mediator. The three of you go into a room. The plaintiff, the person suing, says, this is what the case is about. The defendant says, no, this is what the case is about. This is how much you owe. This is how much I don't owe. Then the mediator tries to get the people to settle. Usually they'll separate the parties in what's called a caucus, maybe two different rooms, where the mediator will talk privately with the plaintiff and then privately with the defendant, and then it's all confidential unless the parties want to share it with each other. And also anything said during a mediation can't be used in court anyway. So many times, let's say 50 to 70%, 75% of the time, cases will settle at mediation. The mediator prepares a document. Everybody signs it and says what the party's going to do. Say, I'm going to pay Scott $50 a week for a year, whatever the case may be. Then you go before the judge approves the mediation, and then the case is done. As long as the parties are realistic and hopefully they can find common ground and settle the case, the mediator's there to offer any kind of creative solutions, because you don't have to just get the money. It could be, all right, money plus something else, or money and write a letter to apologize, whatever the case may be. The role of the mediator is to interpret the concerns and relay the information between the parties, help them frame the issues and define the problems. A lot of cases are settled, but not all cases are. Now, if you proceed, then the defendant, which is the person being sued, may file what's called a counterclaim, which is a set-off or a third-party complaint as provided by the Florida small claims rules, and the clerk will help that person do that. Now, one thing that a lot of people miss is what's called venue. Venue is basically another legal term, which just means the proper place to sue. Because if you're suing somebody, you can't just sue them where you want. There has to be some nexus or connection to the case. And the law gives the person or company who has been sued the right to have the suit filed in one of a few places. And the proper location for a venue could be a couple of different things. First, if you have a contract, it's where the contract was entered into. So let's say we entered into a contract here in Broward, and I can't sue you in Hillsborough or Pinellas. It doesn't make any sense. That's where the contract was entered into. Second, if the suit is on a unsecured promissory note, say you sign a promissory note that you're going to pay somebody money, it's It's either where the promissory note was signed or where the person that owes the money, the maker of the note, resides. Third, if the suit's to recover property, like a foreclosure or something, it has to be in the county where the property is located. It's kind of an obvious one. Fourth, if there's an event giving rise to the suit, it's where the event occurred. Let's say it's a slip and fall, and the slip and fall happens in a certain county. You have to sue in the county where the slip and fall occurred. You can't, just because you live in another county, you have to sue where the accident or the injury occurred. Then you could always sue a defendant where they reside. For instance, if your defendant resides in Duval County, you can always sue your defendant in Duval County because they have a right to defend, and if they're local, they can always be sued there. And then if you have a contract, which is an example where many contracts have what's called a venue provision. They say the contract is entered into here. If we sue, it's going to be here. It's usually where one of the people reside, where something was done, but it's usually something, and many contracts, if not most now, have a venue provision in it. And if money is due and there's no agreement as to venue, it's where the payment's going to be made. So if I was going to pay Scott in Broward, and Scott has to sue me, he can't sue me in Hillsborough, which makes sense. If the case is filed in the incorrect venue, the defendant can ask that the case be transferred to the proper venue. So let's say you have proper venue, you went to the small claims pretrial conference, the judge sent you to mediation, it didn't go smoothly. What happens next? Well, the parties go back before the judge that day, and the judge asks you if it was resolved. If not, the judge sets a trial date, usually a month later, asks you how many witnesses you're going to have, 2, 3, 4, 1, maybe just yourself, and then how much time you're going to need. Small claims case is usually set from 15 minutes to an hour. We're not talking days. Trials like a personal injury case would be, that would go on and on and on. These are trying to be small, short, and to the point. So then you have your trial date. You go into court, and then you basically are your own lawyer. You go to the judge and say, you present your case, you present your witnesses, you present your documents. The other side gets to cross-examine your witnesses. Then when you're done, the defendant goes to present his or her witnesses and documents and the rest of their case, and you get to cross-examine those people. Then the judge considers everything that was going on and makes a decision. Small claims case does not have a jury. Small claims case is just determined by the judge. That's to save money, save time, and to save a lot of hassle. Jury trials are great, but they're difficult to conduct. You really need a lawyer for that, and they take a lot more time and a lot more expensive. So the judge issues you a decision. If the plaintiff wins, the judge puts in the final judgment, how much money you're going to get, and then you have your judgment. Then it's like any other civil judgment. You file it in the county, you file it with the state, and you try and collect it. And you have the ability to levy upon bank accounts and garnish wages and all kinds of other stuff, which is for another day, because collection does take its toll on everything. So that's kind of the small claims in a nutshell. Anything, Scott, you want to follow up on?
Sure. A couple things. Number one, you say the judges are the ones that actually make the call on this?
That's correct. It's just a judge. It's a single judge that makes the call who wins the case and how much money they get. Perfect. Not a jury.
And it's funny how you talk about the location, because many years ago I did have a slip and fall, and all of my legal proceedings took place up in the Orlando area because I got injured at a sporting event, and that's where everything took place. I had to go back and forth from South Florida to Orlando more times than you can ever imagine. Most people would go to Orlando to go to Disney World, and I'm sitting in a mediation in a courtroom every 5 seconds. So Disney World, I didn't feel like Mickey Mouse. I felt like Goofy every time I stepped in one of those places. So
that's a goofy feeling, and that's the unknown thing of venue. Just because you lived in South Florida, if you fell in Central Florida, that's where the case has to be. And I'm sure it was not convenient to go back and forth all the time.
Well, I'll put it to you this way, Ron. I knew the Florida Turnpike inside and out. I knew how from there to get to the minute. And, you know, the Florida Turnpike became my best friend or worst enemy, depending on the result. That's for sure. So since we're in the beloved Sunshine State, why don't you tell me potentially, Ron, okay, some of these claims that can vary from state to state. I mean, are there many? How much do they vary?
Well, as far as I know, Scott, they don't vary greatly. The amount in controversy varies from state to state, which means the maximum amount that you can bring a small claims court. Some of the details vary from state to state. The mediation rules vary a little bit from state to state. The rules of procedure vary a little bit from state to state. But it's my understanding that they're generally similar state to state. So if you're going to be in Michigan, New York, or California, you go to the rules, look up the rules online of the state that you're in, and they're going to be pretty similar. You have to remember, Scott, the whole purpose of small claims is to not have to have a lawyer. Is to make it simple and make it expedient as possible. So the the rules in each of the states is roughly similar as far as I know.
Well, you're right. It obviously saves you legal costs without having a lawyer. Do you find that when a lawyer sometimes are they needed at times for some of these small claims proceedings?
You know, Scott, on occasion, yes. I mean, because small claims is based on amount and not based on complexity of a case, you actually could have a small claims case that gets kind of complex. I mean, let's say you have a breach of contract. Let's say the two parties enter into a contract and the amount of money owed is $6,000. Let's say it was $50,000, everything was paid, and now we're dealing with $6,000. All the rules still apply. You still have to prove your contract case. So it is sometimes a lawyer is necessary. Sometimes it's not. And a lot of small cases, let's say credit card cases, are filed by credit card companies with lawyers. A lot of credit card, unfortunately, we know how the economy is now, especially with COVID and everything else, that people can't, unfortunately, pay off their credit cards. So if you have a credit card debt that's under $8,000, you're going to be sued in small claims. You're going to want to get a lawyer to defend that. You know, if you can afford it, you want to get a lawyer to defend that because all the rules apply. And if a lawyer gets involved, it changes things a little bit. The rules are a little bit different, but it really depends on how complex the case is. I wouldn't recommend somebody handle a complex case in small claims court. Talk to a lawyer, even if it's just to get advice.
Okay, good point. I'm sure a lot of people want to know that. So, all right, well, Ron, let's focus on Florida being the court capital of the world with all these scams. How much do you run across some of these scams? I know when I went ahead and took my 215 license to get insurance, the state exam was a lot harder because of scams. But put it from a court perspective, how complicated it is in this state, knowing full well that scams are a big part of what we do.
You know, Scott, you're absolutely right. Unfortunately, we all know that Florida is a scam capital. It's just known whether we like it or not, and there's a lot of scams. And sometimes they wind up because you get caught in a scam. Sometimes the only way is to file a suit in small claims court, whether it's a scam, let's say a timeshare scam, or a bank-involved scam, or a smaller real estate scam. I mean, there's scams galore, and hopefully you can have recovery. I mean, unfortunately, some of these scamsters, we'll call them, are really good, and you can still take them to court and maybe not fine them after you get a judgment, but it's your best resource. So, yeah, we are a scam-ridden state, unfortunately, and we're very, very litigious state. Unfortunately, or fortunately, I guess you don't want to put a judgment on it, but it's a state where people go to court frequently, people sue over things frequently. It's just the nature of the culture, I think.
Well, there's no question about it, and that leads me to my next question. I know a lot of times when you refer to Florida, it's the call center capital of the world. And why? Because I call them boiler rooms is what they are. There's a boiler room in every plaza, and they're selling everything from auto warranties to so discounted medical plans, and you name it, they incorporate it. So, have you ever had to deal with any situations or heard about call center capital of the world?
I have heard a little bit of that, Scott. There's a lot of call centers in Florida for whatever reason, and a lot of people get taken advantage of. So you'll get calls. Florida lawyers will get calls from people from other states saying, what can we do about it? And it's a good thing. If you're from another state and you're scammed by a call center or any other person in Florida, timeshare, or what have you, it's good to give a call to a Florida lawyer and say, can you help me with this? Or call the court in the county that the call center's in, because it makes a lot more sense to put pressure on them where they are. Let's say you're in Michigan, to pick a state that some of us know and love, and you're getting scammed by a center in Florida. You're better off filing case in Florida. It just makes it simpler and more likely to collect.
Well, obviously we have a third member of our broadcast crew. Candy Ebling just was chomping at the bit to get a few questions in, so go ahead, Candy.
Hi, Candy. How are you?
I'm good. How are you, Ron?
Good, thanks.
So I have a couple of questions. My first question is obviously you have a plaintiff and a defendant. Would you say typically in a small claims court, is it the plaintiff that wins more or the defendant here in Florida?
For what I could tell, it's roughly 50-50 because it really depends on the cause of action. If it's a debt that's owed, the plaintiff is going to win hands down. It depends if you get, unfortunately, a corporate entity on one side and an individual on the other side, or two individuals. But I think the courts are pretty fair. It's pretty split down the middle.
And who has more burden of proof?
Well, the plaintiff has a burden of proof. The plaintiff is the one that has to prove his or her case by what's called a preponderance of the evidence. And all that means is their evidence has to be more than 50% in their favor. So if you, as a plaintiff, could show that, let's say, somebody owes you $5,000, if you can show more than 50% of, on a scale, look at a scale, more than 50%, that the person owes you the money, you're going to win. If you can't, you're not going to win. Now, many people don't know that, but the defendant really doesn't have any burden of proof at all. The defendant doesn't have to disprove the plaintiff's case. The plaintiff has to prove their case. All the defendant has to do is poke holes in the plaintiff's case. And if they can't prove the case, they don't win. Now, that barring that, the only exception to that is if there's a counterclaim. A counterclaim is if plaintiff sues defendant counterclaims or countersues the plaintiff, they have to prove their claim.
All right, so Ron, let's go back to that call center thing a little bit. A lot of these call centers, what they'll do is they'll go out of business under one name, but guess what? They pull a David Copperfield, they reappear under another name. So do you find that a lot of times that the initial one's not collectible, but then all of a sudden they've got a new gig under another name? Because I'll tell you, if there's a scam or a con to be found, it's here, and they do open up on different names.
Unfortunately, Scott, you're absolutely right, and it happens more time than many of us would like. They open up under a name, let's say ABC LLC.
Right. Then
they close, and now they're ABCD LLC. They're two separate legal entities.
Right.
Now, barring some complicated legal theories, generally separate companies are separate companies. So if ABC LLC scams you, you can't go after ABCD LLC. So what these places do, they open, they close, they move, sometimes don't even move and open up a new company. The beauty of the Florida LLC, which people love the LLC, is to shield from legal liability. That's really the main popularity and the love of the LLC. I'm sure you guys have heard of the LLC. It's the buzzword. Everybody wants an LLC.
Yeah. Well.
Except nobody knows how to really formulate one. Being in the banking industry, I can tell you that a lot of people will come into a Florida bank and try and open accounts, and they don't realize that they didn't formulate it properly on Sunbiz.
Ken, you're exactly right. And for those who don't know, Sunbiz is the computer site or the website to form a Florida corporation, and they don't do it correctly. They just go on and think they're doing it, and then they get the paperwork back and it's not correct. And I'm sure you have to send a lot of people back and turn them away, and you have some quite people that are upset, some people that are disappointed, don't you?
We do. I can honestly say, going on to Sunbiz, it can be a little bit confusing because, as you know, in the legal profession, there are legal terms that maybe some of the general population don't know and don't understand, and they think that they don't need anybody to help them. And that's why we have professionals in the industry, in different industries, for that purpose.
You know, you're absolutely right about that. And I always tell people, before you form a business, before you form a company, talk to two people. Talk to a corporate lawyer that does, transactional type law, and talk to your CPA. Because you want to get that stuff done before you go and form it yourself, and then basically have to take everything apart or redo it, and you're just wasting time and money. So it is worth talking to somebody. And there are a lot of attorneys that handle that kind of stuff, and a lot of good accountants around. And I do agree with that 100%. It's good to get your ducks in a row before.
All right, so when we talk about the words fraud Florida, okay, I mean, that's a very broad term, fraud Florida. We're not talking the beaches, we're talking the fraud Florida, okay? Does it make your job a lot more difficult to work through cases to get the results that you want? Or do you find it to be more of a challenge to try to work through all the idiosyncrasies surrounding the state for which we do live in?
Well, Scott, I do find it a challenge. Anybody that handles litigation, and there are many attorneys in our state that handle litigation like I do, it's a challenge to try to use every available legal means to represent your client the best that you can. And sometimes it takes a long time. And unfortunately, there are times that you, as hard as you try, you have to tell your client, we don't think they are collectible. And a lot of times, even before that, we have to get private investigators involved and do all kinds of searches because of all the legal maturations that people go through and companies go through. So you do your best, you make it a challenge, but you always try to do what's best for your client. And I think most attorneys do that.
So Ron, can I ask, how long have you been an attorney?
I've been an attorney 28 years. Started in 1992.
So one of my questions would be, how have you seen your position change as the internet has evolved? Has it increased, some of the claims? Has it decreased? Are they more complex now?
I think it's changed in a number of ways, and I think that's an excellent question. First, the kinds of cases are different because you have a lot more business being done over the internet. Commerce is over the internet, so you have to learn stuff that I never thought I would. Not that I'm a computer expert by any means, right, but I learned stuff I never thought I would learn. And the whole practice of law is different. As I was saying earlier, everything is a lot faster because it's transmitted online. You file your complaints, you file all your pleadings, which are basically your legal papers, online. We have something called e-discovery now, which of course you never have in the past. You can discover, and discovery is a process of getting documents and information used in court. You could discover emails. You can even discover the metadata in the computer, and sometimes you'll have to hire forensic experts to go through somebody's computer to see what information is on there that you can actually use in court. And then there's social media. Social media has changed everything. I mean, social media can be used in court. Social media is discoverable, and sometimes you have to issue subpoenas regarding people's Twitter accounts, their Instagram, their Facebook, et cetera, et cetera. Back, before this all existed, it was basically paper. You would send out a discovery request, let's say a request for reduction of documents. You go to the other side. Give me all the papers dealing with this loan, dealing with this transaction. Now it's all kinds of other stuff. It's interesting, but it's definitely changed things. And now, fortunately, we're able to conduct hearings online because of the pandemic. A lot of the courts in Florida are using Zoom technology, so you'll have a motion calendar hearing that we would have to go to court because of the social distancing issues, we can have them online. So that's also a change with technology.
So do you find that people post things on social media and then they take it down and they think, oh, I took it down, no one can ever see it again, but forensic evidence can go back and find that, correct?
In my understanding, it's absolutely correct, and it happens all the time in cases. I mean, for instance, I don't do personal injury work, but there's a friend of the show that does personal injury work, and he explained that let's say you have an accident and you post, that you're out at a restaurant dancing, let's say. I know it's a little strange now with the pandemic, but for before, and you say, oh, it's gone, they hire a forensic expert, go back and get it and say that person was dancing, and it can be used in court, and it doesn't look good before a jury. So it makes everybody pause to think, what am I posting on social media, and do I really want it to be there? Because it is permanent. Just think, do you want to post something that anybody could see at any time, whether you think they can or not? And if you use that kind of caution, I always tell clients, just think, if you don't want the jury to see this or the judge to see it, it should never be posted.
Well, checking in literally replaces the cameras that they used to have you on during a social media. So I remember many times when I had injured my back, I ended up doing work that was not labor intensive. So I had to go into a position where I was behind a desk, where before I wasn't able to take any labor jobs, and otherwise you would be subjected to a camera. Now, obviously, so like you said, Ron and Candy, that social media is taking the place of a camera for sure. So it is amazing how much social media can make or break in. So many people don't even realize the significance of it, but that's the world that we live in, unfortunately.
Exactly. I mean, exactly. Let's say, in your scenario, which I know you did really hurt your back, but let's say somebody has a back claim and they post on their social media account, hey, I had a great time playing softball with my friends on Saturday. Well, that's discoverable. And the judge is going to say, or jury is like, well, if you were so injured, why were you playing softball?
Oh, yeah.
So you got to, yeah. I mean, that's people. I don't know what people think. They just think it's kind of a separate entity that social media doesn't attach to you, but it's your post attached to you.
Well, they underestimate the significance that social media can make you or break you depending on the situation. And unfortunately, we're finding through COVID-19, there's so many people out there that are taking it for granted that nothing can happen. And the same can hold true in the legal industry, where people are they don't use common sense, common judgment. So there is that carryover effect. Candy, I know you want to say something.
So I was going to ask another question. I was going to say, what has been your biggest challenge in the industry in the last 2 years? Not necessarily barring, obviously the pandemic has given you other challenges, but what would you say is the biggest challenge in small claims?
In small claims court?
Yeah.
The biggest challenge, I think, is getting people to be reasonable to settle their case in mediation. I think people have become very, and there's nothing wrong with fighting for principle,
right.
But the law and principle don't always match up. And if you're owed, let's say just theoretically you're owed $8,000 and you get a $6,000 offer, it's something you really should think about. And a lot of people have been resistant, say, this is what I'm owed, or no, I owe nothing. This is what I'm owed, no, I owe nothing. And mediation is a beautiful thing. Most cases settle in mediation, but you get your people that just are fighting over what they perceive as principle. And unfortunately, when you're dealing with the legal system, it's time and it's money. So you try and get people to say, look, if you can settle something in mediation, is it something that you can not be happy with, but at least live with? If both sides can live with it and neither side is happy, you got a good settlement. Sometimes people listen, sometimes they don't.
Because at least in that point, you have at least some reward, whereas you could risk nothing.
You can risk nothing because it is an all or nothing. I mean, you could think you have this great case and you're owed this money you get before the court, especially in a small claims case. let's say it's a 20-minute, half-hour case. You say everything you can, the other side does, and the judge may look at the evidence, and she may say, well, you haven't proved your case, plaintiff, therefore you get nothing. Where in the mediation, you could have at least got 3/4 of what you wanted.
Right.
Or the same thing with the defendant. I'm not paying them a dime. And then they win their whole case, where you could have maybe paid half and not had to pay the whole thing. So settlement's always good, but I found that it depends what your mindset is going into the case.
So, Ron, on an average time frame, what would you say it takes from start to finish to settle a small claim situation?
Well, usually not that long. Usually just a few months. You file your case. Now, of course, pandemic changes everything, but
right.
You file your case. You get your hearing. Your initial hearing, let's say in a month, maybe a month and a half. If it doesn't settle, you get your court date, maybe in another month and a half. So between 2 and 3 months, you can get your case resolved. Now, 2-3 months may seem like a long time, but a regular, we'll call a regular case, like a non-small claims case, you could be fighting between 2, 3, or more years. So it's really a lot quicker, small claims. That's why it's the beauty of that system.
Now, we talk about 8,000 or less, but I know those are the guidelines, but, what do you know would be the right amount of money, too? Although you say in these cases, 8,000 or less, but have you ever seen any small claims cases go more than that?
No, because the rules that small claims division only has jurisdiction into that amount. If you file a case and it ends up being, you find during the case it ends up being more money, it's got to be transferred to let's say the county or the circuit court, and then it turns into we'll call a standard case. So you got to stick under that limit. You can go as low as $100. Whether it's worth filing a small claims case for $100, I don't know. But if you win, and I didn't mention before, if you do win, you get your filing fee back. So let's say you spend $200 on filing fee, your case is worth $200. You'll get $400 if you win. If you don't win, you don't get your filing fee back. So you got to stick to the jurisdictional amount of the 8,000 or less.
So if you get the 8,000 and you have a filing fee of $250, it'd be $8,250 basically is what you're talking about, and that's what you're
right. Now I've had people or parties or clients. Let's say we'll take this example. We can go to $8,000 now. Let's say they have a claim that's worth $10,000. Well, they have to make a think. They have to think about it. Should I go to a standard court, a regular procedure, and ask for my full amount of money, or do I just ask for the 8, but I can get it done in a few months?
Right.
And then it's a cost-benefit analysis because it's cheaper to get it done quickly. And if it's a close call on the amount, you might want to consider going to small claims court.
How often do you run across that situation?
Oh, a couple times a year. I mean, it's usually a close amount. It's usually within, let's say, $500 to $1,000 of the small claims rules, and you really have to think. $1,000 is a lot of money, but your average attorney's fees can eat that up pretty quickly. So it's just a judgment, and if it's an attorney involved, you talk to the client and you come up with a solution. If the client is going to do it themselves, pro se, then they have to think, because you can represent yourself in any court. I mean, we have a constitutional right to represent ourselves. It doesn't mean it's the best thing, but you can do it, so you have to make that judgment call.
And Ron, once the judgment's been in favor of one party, and let's say the other party owes them money, is there a time frame, or does the judge set a time frame for that settlement to take place?
Unfortunately, if it's a settled case, yes, the parties agree on a time frame and the judge enters an order. But if it's where it goes to a final hearing, a trial, and the judge gives you a judgment, you have a judgment. Let's say you have a judgment for $5,000. You have a judgment where you have to be the one to collect it. And a lot of people don't understand that. Just because you get your judgment, you don't get the money that day. You have to collect it. For instance, you have to do a writ of garnishment. You have to levy on property. You can garnish bank accounts, which you might have dealt with in the past. through if the person doesn't voluntarily pay the judgment. Some people will just say, yes, I know I owe you the money, we'll work out it, and I'll give you the money. But sometimes you have to go after people, and sometimes it's more complicated to collect the judgment than actually getting a judgment. If you get a judgment and have trouble collecting, there are attorneys that do nothing but collection. That's what they do. They collect on judgments. So if it's judgment and you really want to collect it and you're having trouble doing it, you probably best go see an attorney that specializes in that area.
I got to tell you a funny story, Ron. One of my favorite shows growing up as a kid was Sanford and Son. I don't know if you ever got into Sanford and Son.
Oh, yeah, great show.
Yeah, did you ever see that episode where Fred Sanford went into small claims court and he tried to fake a whiplash injury? And boy, did that backfire pretty quick. I don't know if you ever saw that episode.
I actually think I did. That's funny.
Yeah, that's funny. And it was just too hilarious. I mean, this guy thought he was looking for every way to get rich and make money, so he even tested the courts to see if it would work. Well, it didn't. He didn't make it work, but boy, I'll tell you, when I look at small claims court, at least from that standpoint, at least Sanford and Son gives us the comedic value of what it is, but yet, understandably so, there's a serious nature of it as well.
Oh, it is a very serious thing, Scott, but there are and some entertaining aspects. If anybody is in, obviously people are busy and the courts are not having live hearings right now, but when they get back, if you have time and you just want to sit in on some entertaining, interesting things, sit on some small claims hearings, some final hearings that could be interesting, sometimes comedic, you just never know.
Ron, would you say if you watched any of some of the Judge Judy's or that are on TV, how similar are they to a court case or a small claims court that you would go in and sit on if you could?
I haven't watched too many, but from what I've seen, they're not that far off. I mean, usually they're not. The cases aren't as zany and wacky most of the time. They're a little more boring, but the procedure's actually pretty close. Plaintiff states plaintiff's case, defendant states defendant's case, and judge make a decision. So really, it's not from the small claims aspect, not too far off, in my opinion.
Okay.
Very interesting.
And yes, and people find those shows entertaining. I guess that's why they're on TV, right?
Yeah, I guess so.
Well, I'll tell you what. Hey, folks, you're listening to the South Florida Tribune podcast on the WSAN network. My name is Scott Morganroth. My co-host is Ron Renzy and Candy Ebling, who joined the party here. And with all due respect, Candy comes in and she does a fine job. And Ron, what can I say? You can find Ron Renzy, by the way, his photo on the South Florida Tribune. He is our legal consultant as well on the website and guides me in a lot of different areas that we need. And now we're glad to have him as part of the broadcasting division. Just so you know, folks, you're listening to this broadcast, and it's called Small Claims Court in Florida. And I know we've touched a wide range of things, but I'll tell you, when you're in a state like this, you can't leave any stones unturned whatsoever. And Ron, I tell you right now, I don't think we did. The best part about it is Ron Renzy gets to do this again tomorrow on our No Limits broadcast as we talk about pandemic etiquette. And Ron and I and Candy will be talking about that as well. So, Candy, do you have any closing questions for Ron?
No, I think you've done a really good job, Ron. Very interesting.
So, there you go, Ron. The boss gave you the grade. So, again, this is something you don't take lightly. I don't care what state you're in. Small claims is something that you deal with, and how you go about making the decisions of how you approach it. You got to use a lot of common sense and time and judgment, because if you think that this is a get-rich scheme, it isn't. Even though you're able to expedite the cases, you have to understand that are there certain things that you wonder that are worth suing over that stand a chance to get better through the system versus higher risk cases versus lower risk cases for success at all?
Well, I mean, that is definitely on a case-by-case basis, fact-by-fact basis, witness-by-witness basis. You got to see how your witnesses are going to be. You got to evaluate your witnesses, evaluate the other side's witnesses. It's also how people come across. People come across sincere, people come across honest, it's going to go a long way. People come across like they're, being dishonest, or they're full of themselves, or they're being snarky, or they're being sarcastic. One thing to tell you is, if you're going to testify in court, it's not time to make jokes. It's not time to be rude. It's just time to state the facts. And some people come off differently, whether it's a small claims case or not. People come off differently. And Scott, I wanted to mention that we have just like a little sample small claims complaint that we're going to put on the South Florida Tribune site at southfloridatribune.com. So everybody takes a little gander about that. This is just one of many kinds of cases you can file a small claims court. But if anybody wants to take a gander, just go on southfloridatribune.com.
Very good. Well, they will definitely do that. And I think you make a great point on the way you handle yourself in a courtroom. I've always said, if you really feel you've got something worthwhile, you better have the best poker face, and you better have a lot of facts. Because I'll tell you what, any reputable judge can read into that. Let me talk about the value of a poker face, okay? I remember years ago when I did get in an auto accident out in, I believe it was Pompano Beach area. I was on Dixie Highway, and this is a situation where I didn't see a blind spot on one side. And as a result, I told the judge, I said, you know what, Judge, do you think I would have turned over into that lane, okay, if I saw that blind spot? And I looked him with my body language, and you know what, even though these people were able to sue the insurance company successfully, when I told them and I drew it up right in front of them about such and such, you know what the judge said? I will, he can't handle the monetary part of the whole thing, in terms of what they were going to get from the insurance company, but I did not have any points or anything attached to my driving record. It was just a simple, unfortunate situation. And, again, they can read through poker faces too, but if you have your facts to back up what you say, the odds are of a better outcome a lot better. So I just want to put that out there. You're not here to win an Academy Award in court, because that's not what this is all about. The main thing you have to do is be conscious of what you're doing and know what, because you don't want to waste anybody's time for something that's really going to be something that you're preventing another case from being heard. So I'm telling people, don't take this process lightly, and don't take it for granted, because people can read right through you. So by all means, I'm glad that you brought that up. A little tips of advice for our listeners out there.
Absolutely, and I agree.
So, all right, well, with that said, Rob, why don't you let everybody know, our listeners, how they can reach you?
Oh, thanks, Scott. I appreciate that. My firm, the firm's name is Wahlberg and Renzy, and we can be reached by phone at 954-757-1212. That's 954-757-1212, or send us an email at info@wahlberg-renzy.com. That's info@WALLBERG-RENZY.com. And we're happy to give a consultation either on the phone, or now we do it on Zoom, believe it or not.
Why don't you let everybody know how they can reach you on Twitter, Ron?
Twitter at Wahlberg Renzy PA.
There you go. Every reputable company should have a Twitter account. Whether you like it or not is another story. It's what you call one of those love-hate relationships.
Isn't that for sure?
Yeah, with that said, you can reach us on Twitter as well, at Tribune South. Facebook, like the South Florida Tribune page. Instagram, like the South Florida Tribune page as well. Our YouTube channel is South Florida Tribune. The website is www.southfloridatribune.com. You can email us there as well at southfloridatribune@gmail.com. And you can reach me on LinkedIn at Scott Morganroth. You are listening to the South Florida Tribune podcast here on WSAN Network. You can find this broadcast on southfloridatribune.com or wherever you get your podcasts. So Ron Renzy is a member of the Coral Springs Regional Chamber of Commerce. We worked together in the Wednesday referral group, a great group of people, and without that group, I certainly wouldn't have had an opportunity to get to know a lot of the key people for whom at some point down the road you'll be able to see down the road. But meanwhile, Ron, we'll have a 23 and a half hour break before we do this bad boy again tomorrow, maybe 22 hours, but somewhere around there. Well, we will be doing another edition of No Limits as well. So meanwhile, on behalf of Candy Ebling and Ron Renzy, my name is Scott Morganroth, the Motor City Madmouth. thank you for joining us here on the South Florida Tribune podcast. Good night, everybody.